A very good afternoon to all my dear students. Today we are going to discuss about the concept of second appeal as provided under the Code of Civil Procedure. But before starting with the same, I just want to point out certain important points which is of immense importance for the better understanding of this topic. My dear students, as you all are aware that there are two words involved in today's topic, that is second and another is appeals. As such, it is necessary for me to provide you the definitions of an appeal. As you all are aware that the word appeal has not been defined under the Code of Civil Procedure. Furthermore, various other definitions have been defined under Section 2 of the Code of Civil Procedure. But the legislature, while enacting the law on this point, did not put this definition in the section of the Code of Civil Procedure. As such, we have to take the help of the law dictionaries from where we may able to trace the meaning of appeals. As per Chambers Law Dictionary, 21st Century Dictionary, 1997 volume, at page number 59, appeal has been defined as the judicial examination of the decision by a higher court of the decision of an inferior court, meaning thereby appeal is a proceedings by which the defeated party approaches a higher court or higher authority against the decision of the lower authority. And in this regard, the relevant case law is that of Nagendranath Dey versus Suresh Chandra Dey. So in this background, we have to start with the today's topic, that is second appeal. The relevant sections for the or pertaining to second appeal are given under Section 100 to 103. Furthermore, we have also to taken into account Section 107 and 108 and also Order 42 of the CPC for the better understanding of today's topic. As regards the second appeal is concerned, it is submitted that it is not a natural or an inherent right attaching to litigation, and it does not exist unless expressly conferred by the statute, meaning thereby, if the statute does not provide the remedy pertaining to second appeal against the order of the or the against the decree passed by the appellate court in a civil suit, the same cannot lie. Further, Section 100 of the Code of Civil Procedure allows filing of second appeal to High Court. So my dear students, from this, you may infer the difference between the first appeal and the second appeal. As regards the first appeal is concerned, the same needs to be filed before the higher court, and that not necessarily to be high court, but in the case of second appeal, it must fly to the high court. Further, and the ground on which the second appeal may be filed before the high court, it must involve a substantial question of law, but not any other ground. So this also makes a difference between the first appeal and the second appeal as such. In the case of first appeal, the impugned decree may be challenged not only on law, but also upon the facts as well. Furthermore, the first appeal may also lie against the impugned decree on the ground of mixed question of law and fact. But this is not true in the case of second appeal, which only lies only on the substantial question of law. But there are certain exceptions given under second appeal, which provides that in certain circumstances, an appeal may lie on the question of fact, which I would like to discuss it later on. As far as the nature and scope of second appeal is concerned, the same would be filed before the High Court of the state. And second, in this, every decree passed in appeal is the subject matter of the second appeal. Whereas, in case of first appeal, it may be filed in case of every decree. Furthermore, it may also lie against certain orders which are specified under section 104 of the Code of Civil Procedure and under order 43 of the Code of Civil Procedure. Further, second appeal may lie from the decree, from the impugned decree passed by any subordinate court, meaning thereby the impugned decree must be passed by an inferior court to that of High Court. Furthermore, it involves a substantial question of law. So these are the essentials to be taken into consideration while drafting a second appeal before the concerned High Court. Second, such appeal lies also against an appellate decree passed ex parte, meaning thereby an ex parte appeal, an ex parte second appeal may also lie before the High Court. Now, we will go further and will try to understand about the grounds for filing a second appeal before the High Court. So, my dear students, the grounds are as under. Number one, it involves a substantial question of law. Further, it must be filed through a memorandum of appeal, which must precisely state such questions. And High Court, at the time of admitting the appeal, should formulate such question, and such questions here means is that they involve substantial question of law, meaning thereby to frame a substantial question of law, it is the duty of the High Court to formulate such question and may take the assistance of the parties involved in the case. Thereafter, appeal shall be heard only on that question and not on any other question. Further, respondent may argue that the case does not involve such question, then High Court is empowered to hear second appeal on any other substantial question of law not formulated by it if it is satisfied that the appeal involves such question. So from this, my dear student, we may infer that High Court is having the power or the jurisdiction to formulate such questions which have already not been framed by it earlier, only on the ground or only on the satisfaction of the High Court that the case involves such question. Further, what is the object of second appeal? That the object of the second appeal is that the second appeal may not become a third trial on facts or one more dice in the gamble. As such, the right of appeal is confined to the cases where a question of law is a substantial one. So, from this, we may infer that the scope of the second appeal has been restricted, thereby to restrict it up to the substantial question of law only. Further, what do you mean by substantial question of law? My dear student, the said expression has not been defined under the Code of Civil Procedure. As you all are aware that various expressions have been defined under the Code of Civil Procedure, such as foreign court, foreign judgment, decree and order, pleader, government pleader, High Court, etc., and so on and so forth. But the legislature did not or failed to explain or define the said word or said expression under the definition clause of the Code of Civil Procedure. But we may try to define the same. The term involves suggests that a question must arise in the case and it is necessary to decide such question. Further, the Supreme Court has also laid down the test for determining whether a particular question is a substantial question of law or not. And this was so dealt by the Supreme Court in the case of Chunilal B. Mehta and Sons Limited versus Century Spinning and Manufacturing Company Limited, AIR 1962, Supreme Court 1314, wherein Supreme Court has held that a question to be of substantial question of law is that, number one, whether it is of general importance or whether it is directly and substantially affects the rights of the parties, and if so, whether it is either an open question that it is not finally settled by this court or by the Privy Council or by the Federal Court, or is not free from difficulty or calls for discussion of alternative views. So from this, we may infer that these are the essentials to be taken into consideration while formulating a substantial question of law by the High Court in a second appeal pending before it. Formulation of question is a sine qua non and a condition precedent for the exercise of the power by the High Court. Is there any exception where the formulation of the substantial question of law is not needed? Answer is yes. Yes, there is an exception, and that exception is if second appeal is dismissed at the admission stage itself, meaning thereby if at the initial stages or at the admission stage of the second appeal, the High Court, after going through the second appeal or the memorandum of second appeal, came to the conclusion that it does not involve any substantial question of law and thereby dismiss the second appeal at its threshold, then it is not needed for the High Court to formulate such question. Now, whose duty is to formulate substantial question of law? Answer is, it is a duty of the court and not of the parties as such. Now, I would like to give you some of the examples from which we may infer or which may provide us the examples regarding substantial question of law or wherein substantial question of law is involved. Number one is question of law on which there is a conflicting of judicial opinion. So my dear students, this would also tantamount to substantial question of law. Second is recording of finding without any evidence on record. Third, inference from or legal defect of proved or admitted fact, disregard or non-consideration of relevant admissible evidence. Further, placing of onus of proof on a wrong party. Next, a question of admissibility of evidence. So these are some of the examples of substantial question of law are involved. Now, I would also like to give certain examples where substantial question of law is not involved, meaning thereby it would not come under the category of substantial question of law. And these examples are concurrent findings of facts recorded by the court of below. Second, where two views are possible. Third, where a new case is sought to be made out in the case of second appeal. Next, where the question of law is raised too general or omnibus in nature, and where the finding of the fact has been attached on the ground that it is erroneous. Second, whether no second appeal to be filed in certain cases. The relevant sections for this are given under section 101 and 102. Section 101 provides that no second appeal is maintainable except on the grounds specified in the court. Further, section 102 provides no second appeal lies in any suit where the subject matter of the original suit for recovery of money does not exceed rupees 25,000. So from this, my dear students, we may infer that second appeal would not lie from a decree if the money decretal amount is less than 25,000 rupees. No letter patent appeal. This is provided under section 100A of the CPC. Section 100A, which was added by or inserted by 1976 amendment, it provides that no further appeal shall lie against the decision of a single judge of the High Court in second appeal. Now, the next question which needs or is of very immense importance is that what is the limitation period for filing the second appeal? The second appeal needs to be filed within 90 days from the date of the passing of the appellate decree. Next, what is the form of second appeal? Answer is, it is maintainable only when it provides for substantial question of law. Memorandum of second appeal must precisely state such questions. However, unlike the memorandum of first appeal, it need not set out the grounds of objections to the decree appealed from. Now, whether the High Court is having the power to decide any issue of fact, my dear students, as you all are aware that second appeal would lie only in the cases of or case involves substantial question of law, meaning thereby no appeal lies in case of issue of fact. But section 103 provides certain exceptional circumstances under which a second appeal may also lie from an issue of fact. So general answer is generally no, but in following exceptional cases, it may be allowed. And these cases are if such has not been determined either, if such a question has not been determined either by the trial court or by the appellate court or by both. And secondly, it has been wrongly decided the issue of fact determined by such court by reason of its or their decision on a substantial question of law. So these are the two considerations on the basis of which we may say that generally the High Court would not entertain second appeal on the issue of fact, but in these circumstances, exceptional circumstances, the second appeal would lie. Now, what is the procedure at hearing? As far as the procedure at hearing is concerned, the provisions relating to first appeal shall also apply to second appeals as well, meaning thereby the provisions as laid down under 41, Order 41 CPC would also be applicable to Order 42, which deals with the procedure for second appeal. So this is all about, my dear students, this is all about today's lecture. Hope you have learned a lot out of it. In case of any query, then you may write it to me at my email ID, that is rahul.arora.gn@jagannath.org. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on general provisions as to appeal. We'll meet, thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.